important issues, and particularly as we try and bust through some of the anti-regulatory myths that have been persistent out there, certainly under a series of, frankly, an avalanche of misguided and short-sighted proposals that affect us every single day in terms of our public health and safety and our natural environment. Today marks the 75th anniversary of the Fair Labor Standards Act. It was signed by FDR in 1938, guaranteed a minimum wage, prohibited child labor. It's also the day after, and we're probably going to hear throughout this briefing, a couple Supreme Court decisions that made it much more difficult for employees to bring discrimination claims. And it's also a day when the President is going up to Georgetown this afternoon to invoke the power of the underlying statute, frankly, of the Clean Air Act, and use regulation and some other measures to take a proactive stance on combating greenhouse gases that contribute to climate change. All of that sort of underscores, frankly, that within this body and within every branch of government, these important decisions are being made every single day that affect our health and environment. Before introducing the panel, I want to thank Representative Conyers, Representative Cohen, the House Judiciary Committee, James Park, Susan Jensen, my colleagues at the Center for Progressive Reform, in particular James Goodwin, and my colleagues at the Coalition for Sensible Safeguards, Ginny Robnett, and Catherine McFade at the Center for Effective Government. So on this auspicious morning, we have in store for you quite a treat. We have a great panel lined up. Let me just briefly introduce them, and then I'll get out of the way. To my far left is Professor Sid Shapiro. He's the University Distinguished Chair at Wake Forest University School of Law. He is a board member and a founding member of the Center for Progressive Reform and our current vice president. He's a nationally recognized expert in administrative and regulatory law, and he's testified before Congress on many occasions. So my immediate left is Peg Seminario. She's the Director of Occupational Safety and Health at the AFL-CIO. She is a leader in this town on protecting workers' health and safety, and we're delighted to have her here. And on my immediate right is John Walk, longtime advocate and senior attorney and director of the Clean Air Program at the Natural Resources Defense Council, well known to all of you. John has been actively involved in these issues, particularly from the environmental standpoint for many, many years, and is a trusted resource for all of you going forward. Okay, so without further ado, I think I'll turn it over to Sid.
Thank you, Jake. Good morning, everybody.
Good morning.
In the administrative law system, it's pretty universally accepted that we're trying to balance three values. We want accountable government, we want fair government, but we also want effective government that's in a position to actually achieve the statutory mission that it has been given by Congress. Unfortunately, the trend over the last 20 years, or perhaps even a little more, has been towards reduced effectiveness. And we've now arrived at the point, in many ways, the regulatory system is just dysfunctional. It just doesn't work. And there are two general reasons for that. First, as I will talk about in my remarks, we keep ramping up the degree of accountability, adding more and more procedural obligations to the system to the point where it's become extraordinarily burdensome. At the same time, the budgets of nearly every agency, if not everyone, have been cut, and cut sufficiently that in real dollar terms, most agencies have a quarter to 40% of the budget they had at their highest point. So they have 60% or so of the total amount that they had earlier. Critics of government, nevertheless, seek more of the same. even more accountability, and even less money to pay agencies to meet these analytical obligations. And they attempt to make their case based on a number of what can only be called regulatory myths. The most popular a few years ago, 2 or 3 or 4, but it's still running around, is a study that claims annually regulations in the United States impose on us $1.75 trillion in costs. And this number gets repeated and repeated ad nauseum, with no attention paid to the fact that the study itself, the underlying study, the one that generated the numbers, has been thoroughly debunked by the Congressional Research Service, by the Economic Policy Institute, and by my own organization, CPR. In fact, in testimony not too long ago, Cass Sunstein, when he was still director of OIRA, termed it, the number, an urban myth. And it is indeed mythical. The second claim is that the word regulation can't be said by a critic of it without appending the adjective job-killing regulations. So regulations are job-killing, and particularly in a time when our economy is still limping along, if the claim were true, it could be worthy of our attention. But to the extent that we academics have studied this claim, it is simply not true. What the literature shows, what these economic studies that various people have done show, is that typically regulations on balance have no net effect on jobs, and in some instances they actually increase employment. So why might that be the case? Well, what the critics are assuming, and what they want the public to assume, is that when we spend money coming into regulatory compliance, that money somehow disappears. It goes down a hole never to be found anymore. Hence, the cost is a real cost and detracts from the economy. Of course, in fact, when we require actually, a corporation to regulate, it turns around and spends money on the regulation. It has to hire people to come into compliance. It needs people to ensure it's meeting the regulation. It hires consultants. It spends money on equipment to abate whatever hazard is being regulated. So the actual cost of the regulation gets respent in terms of economic activity. That is why the studies show that regulation generates about as many jobs as it costs us, and in some instances, because it leads to improved technology and other economic benefits, it's actually a net benefit to the economy. But in any case, it's not job killing. Another myth is that regulatory costs run way in advance of benefits. There are lots of problems in trying to do cost-benefit studies, but there are any number of studies, typically by conservative think tanks, which claim that this regulation or that regulation ends up costing hundreds of billions of dollars more than the benefits it brings to the economy. Again, I can't think of one of these claims which has not been significantly debunked. The Office of Information and Regulatory Affairs in the White House every year puts out a report, although they're running way behind on the latest one, on the totality of costs and benefits in the economy. And that report has showed for years, in total, a positive net benefit of benefits over regulations, according to the data which are submitted to OIRA by agencies. So agencies themselves are reporting these benefits and that they exceed costs. Moreover, Cass Sunstein has testified several times that in his tenure as OIRA director, which of course just ended, that he wasn't aware of regulations being submitted whose benefits didn't exceed its costs. Now, as I said, cost-benefit analysis is very difficult to do. It's hard to get hard numbers on these things, and as a result, it's eminently manipulable. So we're going to continue to see these studies where people can gin up numbers showing the opposite is true. But these certainly are contestable numbers, and in many cases, in fact, I think it's fair to say, they've been disproven. Finally, the regulatory critics would have us believe that the government is running amok, that there's simply a lack of political and legal accountability, and hence the necessity of adding more accountability to the system. In other words, they would like the public to believe the baseline is zero, and so we desperately need some control over these agencies. In fact, the opposite is true. There are simply so many analytical steps now required that, as I mentioned earlier, the system has become dysfunctional. This is a chart which is on the slide and the original version, which Public Citizen was kind enough to bring down to us. I think they only have one. It's the only one in Washington. And you're privileged to be here in the room with it. Well, as you can see, nobody can read it. You can go up afterwards, and you can't even read it as it's blown up. There are so many steps and so many requirements that just to explain them briefly generates a chart which is what? Well, I'm short, but that's tall. We got to be talking 25 feet tall, and you certainly couldn't read it on my PowerPoint slide. You're certainly not going to be able to read it even in that function. So the fact of the matter is this is the baseline. It's not zero. It's not anything close to zero, even though the regulatory critics would like you to believe otherwise. In testimony a year or two ago, I offered a calculation of how long it takes to generate a controversial rule. And I tried to be very conservative in terms of the amount of time that I allocated to the various regulatory functions. And in fact, before I gave the testimony, I sent this around to, had to be at 15, maybe 20 other law professors, and asked them to look at my estimates and let me know if they thought I was overestimating it. And to a person, everyone came back and said, well, this is really the minimum, and it's got to be more than that. So just to quickly walk you through what would be a minimum for a controversial regulation. We're talking about 12 to 36 months of development. And then the notice of proposed rulemaking, which is justification, has to be sent to OIRA along with a cost-benefit study. This assumes 3 months of review at OIRA. In fact, they're running way behind that. The executive order requires OIRA to complete review within 90 days, and I would guess somewhere now, James, I don't know the last time we counted, 50%? About 50% of the rules are running past 90 days. One reason for that is that the critics have been so successful in generating these anti-regulatory myths that the White House just ran scared in the president's run-up to his re-election. And they didn't approve any regulations for about a year, certainly for about 10 months. So there's a 10-month delay in current regulatory schedules right there. 3 months of public comment, 12 months to write a final version of the rule, which is not much time given agency budgets. A 2-month delay so Congress can engage in the Congressional Review Act, and then somewhere between 12 and 36 months to complete judicial review. And I don't know, we can ask Peg and John whether, I can't think of a significant controversial rule that hasn't been involved in litigation for the last decade or two. So we always have judicial review. And I'm already at 4 to 8 years. Now, let's see what I didn't count. I didn't count an informal hearing, which some agencies, are, like OSHA, are required to have. That should say SBREFA. I got the misspelling here. But the Regulatory Flexibility Act, the Small Business Accountability Act, actually, requires, again, some agencies, principally EPA and OSHA, to meet with small business panels. It assumes that the comment period is only 3 months, and typically they're far longer than that. It assumes that the regulation doesn't impose any paperwork requirements, because if it does, there's a separate regulatory requirement that OIRA has to review the paperwork requirements. It assumes, as I mentioned, that it's only 3 months at OIRA, and it assumes only 12 months for the final version. So if you just add a little bit of time for these functions, you probably add anywhere between a half a year and 2 years. So now I'm out to 4.5 to 10 years for controversial regulation, and we could go down some recent regulations, and any significant one is going to be somewhere in this time period. Despite the fact that we've built into the system really an extraordinary degree of ossification, the various reform proposals that have come up, particularly in the House, would add even more procedures. The leading reform proposal, I suppose, is the Regulatory Accountability Act. That would have, and this is the old version, there's a new version out, and I haven't counted the number of regulatory requirements. It would add to the existing requirements. But the old version would add 60, count them, 60 new analytical and procedural requirements. That's in addition to what we see in the Public Citizen Chart. So I don't know what that chart costs them, but if this thing passes, not only will it end the regulatory system, but they're going to have to spend a lot of money on a second chart to hang beside it. Because I'm sure with 60 more, it will take them another chart of equal size to get all these things written down. Worse in some fashion, I suppose, is the REINS Act. The REINS Act, if it ever got passed, would end agencies' authority to promulgate as binding any regulation that is significant, which is to say has $100 million costs or more. For regulations with $100 million cost or more to go into effect, it would have to be approved by both houses of Congress and signed by the President. Now, I don't have to tell anyone sitting in this room how little is going through your chambers these days. And the likelihood that any regulation is going to get through this gauntlet, which we now all live with, is fanciful. I mean, this literally would end government regulation. Another bill worth looking at is the Independent Regulatory Review Act. Currently, the independent agencies are not subject to some of the analytical and procedural requirements, although sometimes voluntarily they obey them. And this bill would sweep all the independent agencies into the same morass in which the non-independent, the executive branch agencies find themselves. And it's sort of remarkable that this is being pushed by Congress, because the whole rationale of the independent agencies since the 1930s is that we want these agencies to stand a little bit back from the normal regulatory system. We want them to have some degree of independence. That was Congress's purpose. And this would simply rewrite about 50 years of intention by not essentially treating them any differently. So what would real reform look like? Well, there's a limit to what we can do legislatively, obviously, at the moment, but our time will come again. In the meantime, it's crucial that we fend off more dysfunction. I can't imagine what would happen if any of those bills passed and actually were signed into law, given the current state of the regulatory system. And I think it's also possible that the executive branch could do a better job of innovating its way through the system. They've been very conservative. They have not really wanted to sort of buck the trend. But there are a number of proposals, we can discuss those later in questions, of ways that the agencies themselves, particularly if they had the backing of the White House, might be able to shortcut some of this, and that would be all to the good. In the future, it really is necessary for Congress to act to rebalance the system, to streamline rulemaking, and most importantly, to increase agency budgets. But that's probably for another day.
Thanks. Thank you, Sid. And if folks are interested in just further documentation on debunking, particularly the 1.8 trillion number and other ridiculous stuff, there's lots of materials over on the table. Okay, Peg?
Thank you very much. Good morning. So I'm the Safety and Health Director at the AFL-CIO, and I've been there for a very long time. One of the benefits of having been working in this field for a long time is a knowledge and experience that actually it was once possible to get things done. Many of you are quite young, and so all you know is what we see today. But I started doing regulatory work in safety and health, primarily with OSHA, back in the 70s. And that was a time that actually was sort of a high watermark of protecting workers. As Sid said, it wasn't just agency budgets, which were more robust at that point in time, but also agency activity. And coming off of environmental crises, workplace crises of the late 60s, the passage of these groundbreaking laws of the Occupational Safety and Health Act, the Clean Air Act, which John has worked with for many years. The Congress and the country made a commitment to address these significant problems, and progress was made. So we were able to make significant gains in putting in place some very important standards on protecting workers from asbestos. Until the 1970s, there were no workplace regulations on asbestos. As a result of not controlling this hazard, we have 10,000 workers dying still every year from those exposures. But we were able to get the first asbestos standard. We were able to get standards on lead, on cotton dust put in place. And these standards, the impact of them was to change the practice and norms and conditions in workplaces all across the country. But most importantly, the impact was to reduce exposures and save workers' lives. And so it was a very exciting time to be doing this kind of work because, again, public policy was actually having an impact on people's lives, which for those of us who do this work, that's the reason we do it. But as soon as these regulations started coming forward, there were objections, there were protests, and over the years what has happened is that the process has continued, but as Sid has indicated, it has gotten harder and harder. There have been more and more requirements added to the regulatory process. I mean, there were always requirements. It was never that OSHA or EPA could just go off and develop a rule. They had legal requirements. These rules had to go through a public process. They had to do analyses on costs. They had to do analysis on impacts of the rules. And this was done in a very public process, and these rules have always been litigated from the get-go, and the vast majority have been upheld. And just to give you an example of This was one of the first rules that OSHA issued. It was a rule in 1974, final rule on carcinogens. Covered 14 very hazardous carcinogenic agents. And so there are 14 rules, actually. The preamble, the justification for those rules was 4 pages long. One of the last standards that OSHA issued most recently was a standard on cranes and derricks, a more modest standard dealing with the specific safety hazard, which are generally easier to do than health standards. And this rule had a preamble of some 200 pages long, but if you go into the document and you look at all the analysis, it's thousands and thousands of pages looking at feasibility, looking at costs, looking at risks, and as I said, the analyses that are required on the health side are even more significant. But what has also happened is just the time that is required and needed to get these rules through the process has become, incredibly long. Sid gave you his estimates. Last year, the GAO put out a study specifically looking at OSHA rulemaking and saying multiple challenges lengthen OSHA standard setting. And I would, for anyone interested in this issue, this really gives a good case study of what is required in rulemaking, the steps agencies must go through, the difficulties. And they found from start to finish, on average for OSHA, it was about 8 years. And that wasn't even considering some of the rules that are currently, in process, which have not been moving forward. One of the myths that we have heard in recent years is that under President Obama, there has been a regulatory tsunami, just an avalanche of rules that are coming forward. In my area of the world, there has not even been a ripple. In President Obama's first term, his record at issuing final safety and health rules was worse than the Bush administration, which was really pretty terrible. So since they have taken office, it's now been 4 some odd years, we have had 2 major safety and health rules, significant safety and health rules come out. One was the standard on cranes and derricks, which I'll talk a little bit more about. That came out in 2010. Another was a standard that industry had wanted on harmonizing hazard warnings in the workplace to a global standard that had been worked on. So it was essentially trying to reduce trade barriers for employers. That standard was a major rule. And then there was another standard to codify shipyard standards and to update them, which was not considered major. That's it. That's the only progress we have made in putting in place new protections in the occupational safety arena. At MSHA, progress has been better. Why? Because back in 2006, we had dozens of coal miners die in this country in a whole series of explosions, and Congress passed legislation ordering that there be rules. Until that time, there weren't any rules under the Bush administration. More recently, we've had some regulatory activity. Why? Because in 2010, we had 29 miners die in West Virginia. That's the only impetus for moving forward. So where are things currently, the rules that are not moving? There is a rule to protect workers against silica. That's basically quartz in rock. And so any of you who go down the street and see work being done, cuts, sidewalk, road work, dust, that's silica. It causes silicosis and it causes lung cancer, and we've known about it for centuries. The standard that's on the books today was a standard that was adopted as a 1968 rule. It doesn't protect workers, no knowledge, no information basis on lung cancer. That rule started going through the rulemaking process, this current rulemaking, 1997. 1997. Today, where is it? For the last 2.5 years, the draft proposal has been sitting at the Office of Management and Budget under review under the executive order. The 90-day review on this very common hazard has been sitting there for 2.5 years and hasn't moved. So don't tell me, I don't believe that there is a regulatory tsunami that is happening, at least when it comes to workplace safety rules. And I think if you look at the record, it's not happening across the board. The cranes and derrick standard at OSHA is instructive because this was a rule that industry wanted, unions wanted, the government wanted. There was a standards advisory committee, a negotiated rulemaking that got together under the auspices of OSHA in 2002 and 2003, and within 1 year, they produced a rule to basically put in place safety requirements, training requirements, certification to deal with cranes in construction. So that rule was delivered to the agency in 2004. And there it's at. The rule was ready, people supported it, and there it's at. It then still had to go through the entire process. The fact that everyone agreed on it, that they were codifying practice, best practice, that didn't matter. It still had to go through the SABRIFA process, still had to go through all the feasibility analysis, still had to go through all the cost estimates, still had to go through the OIRA review, and finally, the proposal came out in 2008 and a final in 2010. And so the process doesn't even work when everybody agrees that there should be a rule. So what happened during this time period when this rule was sitting there? We had major crane collapses in New York City, in Miami. We had, dozens of workers die. We had pedestrians being killed by falling cranes. And that was really the only thing that forced the rule going forward. So what is the impact of rules not moving forward? The impact is more workers are exposed to significant hazards, more workers are killed, more workers are injured. So today in this country, we still have 4,700 workers, 4,700, that's 13 workers a day dying on the job. There are 50,000 workers a year dying from occupational diseases, exposure to chemicals. The chemical standards in this country largely are ones that were adopted when OSHA was passed in 1970 and were based on data from the 1950s. That's the state of protection against toxic chemicals in this country, and there's been no ability to really move forward except on some particular standards. The cost of all this, and these aren't my estimates, these are estimates that come from Liberty Mutual, the big compensation insurer, academics who have looked at this, and the National Safety Council, are in the range of about $250 to $300 billion a year. Let me repeat that, $250 to $300 billion a year, and only about 25% of that is being picked up by workers' compensation. So the rest of it, workers are paying, their health insurance is paying, and you're paying. You're paying as a taxpayer. These workers basically go on welfare. They go on Medicare. It's all shifted out of the workplace. And so these impacts of not regulating and not protecting are absolutely horrific and significant. So this summer we've seen 15 people die, a number of them workers in West Texas with a major explosion at this fertilizer distributor. That particular facility had never been inspected by OSHA. We just had a big explosion down in Louisiana, where a chemical plant exploded. That facility had never been inspected by OSHA. So we've got problems at both ends, both the lack of regulations, but also the lack of oversight. So as Sid said, there's some real need here to move forward and make this process work, to put the norms in place and the standards in place, but as importantly, to provide the support and budgets for these agencies to go out and do their jobs and inspect workplaces and bring about changes in conditions that indeed can save and will save workers' lives. Thank you.
Great, thank you, Peg. It just seems remarkable that we went from disaster to disaster before any action is taken in any shape or form. It doesn't seem like any way to do regulatory policy or any way to promote economic growth for that matter.
Good morning. My name is John Walk. Thank you for attending today. I am the Clean Air Director for one of the oldest and largest environmental nonprofits in the country, named the Natural Resources Defense Council, or NRDC. I have been there for 13 years. I was an attorney at the U.S. Environmental Protection Agency, a civil servant in the Clinton administration, and before that I was a private attorney at a law firm representing corporations and trade associations on environmental matters. I've been an attorney about 20 years. I'm going to touch very briefly upon an that surrounds a lot of these legislative attacks on regulatory safeguards. And then I'm going to talk about two examples. My memory and brain work best when I remember stories. So I'm going to leave you with two environmental stories to help you, fix a greater understanding of some of these attacks on regulatory safeguards. The overarching theme of the bills that Sid put up on his PowerPoint and that I'm going to mention that I have perceived is these bills represent indirect attacks on the implementation and enforcement of safeguards and substantive statutes or laws that are too popular to be amended and weakened directly. Okay, so we have laws like the Civil Rights Act and the Clean Air Act and worker safety laws and food safety laws that political critics cannot manage to amend directly in Congress because one chamber won't pass it, the president won't sign it, what have you. So what they've done is very cleverly, and this has really been a campaign that started with the Gingrich Congress in 1994, is they've resorted to these indirect attacks that promise to provide greater accountability or greater transparency or greater cost effectiveness. What they are really designed to do, and this is true across the board, is to obstruct the enforcement and implementation of these substantive safeguards that they can't amend by addressing the statutes directly. It takes them out of the committees that have jurisdiction over those statutes and puts them in other committees where the actual merits and benefits and substance of those safeguards aren't even addressed. And I've testified at these hearings, and I know I testified at one about 2 weeks ago in the Judiciary Subcommittee in the House. Here's my first example. There's a bill called the Regulatory Accountability Act. Sid mentioned it. There's a version in the House. There's a version in the Senate. The centerpiece of this law would direct an agency and try to assure that an agency adopts what is called the least burdensome or least costly alternative when it issues regulations. Well, least burdensome or least costly for whom? Well, for industry, okay? It is most definitely not the least burdensome to the public that is attempted to be protected by cleaning up the air or protecting worker safety or protecting food safety. So why was that language selected? Why was that legal standard selected? What do we know about it? Well, we know a lot, okay? That language has been the centerpiece of an environmental statute called the Toxic Substances Control Act, or TSCA, that is widely agreed to be our most meaningless, ineffective, broken environmental statute. Okay? And the reason is because of that language. Okay? So here's my story. When you hear the words Regulatory Accountability Act, I've already given away my punchline. I want you to remember the word asbestos. Okay? RAA, asbestos. RAA, asbestos. All right? So under this TSCA law, EPA in 1989, under the radical first Bush administration, proposed a rulemaking after 10 years of analysis, millions of dollars and a 45,000-page record to ban asbestos. Okay, 50 countries across this globe have banned asbestos. The United States is not one of them. All right, there was this rule to ban asbestos in 1989 by the radical first Bush administration. As Peg said, about 10,000 Americans die due to asbestos exposure every year. A federal court in 1991 interpreted this law and the least burdensome alternative language and ruled that EPA could not ban asbestos because EPA had not met this test. In effect, the ruling makes clear that the test is impossible to meet. Okay? Is this just hyperbole on my part? No, it's not, because in 20 years since that ruling, over 20 years, EPA has never regulated another toxic chemical under this statute using that authority. Not once. Okay? The statute is a dead letter because of that language. And that is the centerpiece of these attacks on the regulatory system today under the Regulatory Accountability Act in both the House and the Senate. The CEO of SC Johnson that makes Pledge and Windex and Glade has testified in Congress that your child has a better chance of becoming a Major League Baseball player than a chemical has of being regulated by EPA under TSCA. That's exactly right. Okay, it's a broken, dead statute. And again, it's because of that very clever language that if you just heard it, sounds reasonable, right? Well, we should require the least costly or least burdensome alternative. That language has legal consequences, and it's a regulatory guillotine, okay? My second example, Sid mentioned the regulations of the Executive in Need of Scrutiny Act, the REINS Act. You get it like the rein in a horse, you rein into out of control regulatory state. I can say absolutely that this is the most destructive legislation aimed at safeguards that I've ever seen in my 20 years as an attorney, hands down. Nothing close, okay? And why? It's because it takes advantage of what is just a fundamental system of dysfunction that we have in Congress right now. We have parties controlling either chamber that just cannot pass legislation. Here's my story. Here's the example. EPA has passed long overdue health standards to clean up smog, soot, mercury, arsenic, lead, lots of carcinogens from power plants that burn coal. Okay, these were the centerpieces of EPA's clean air achievements in the first term of the Obama administration. Those two rulemakings together have been projected to avoid up to 45,000 premature deaths every year, tens of thousands of heart attacks, hundreds of thousands of asthma attacks, and millions of days when people will not have to miss work or school due to reduced pollution and the ability to lead healthier lives. Okay? Both of those rules came up for votes in the Senate to try to kill them, to repeal them, using a statute on the books today called the Congressional Review Act. The Congressional Review Act basically just says if the House tries to overturn a rule and the Senate tries to overturn a rule, they both cast those votes, it's signed by the president, it's just like any other law, the safeguards are overturned. That's fine, that's democracy. Got no problem with that. I fought it like that, but both of those votes failed in the Senate. The Senate did not manage to overturn those safeguards. And so now we're going to have up to 45,000 Americans that will not die prematurely as a result of these rules being enforced really starting next year. If the REINS Act had been the law of the land, both of those regulations would be voided, killed, repealed, eliminated. Because it only takes a House vote to kill a rulemaking or a set of health standards under the REINS Act. Just one chamber. You don't need the Senate. You don't need presidential signature. You just need one chamber to put his foot down and say no. Okay? With the amount of regulatory dysfunction that, again, I don't need to explain to this audience, it is the death knell, it is the guillotine for health safeguards that one political party opposes, but that they don't have the votes to change or amend using democratic means like the Congressional Review Act or other types of legislation. Okay? We know that the House was trying to kill those rules, and they passed laws to kill those rules. It was called the Train Act, like a locomotive. That was the acronym. The last one I'm going to mention, just to give us some time for questions, is a bill that goes under kind of the popular euphemism of the sue and settle legislation, a term coined by the Chamber of Commerce. But the official title of the bill is the Sunshine for Regulatory Decrees and Settlement Acts of 2013. I testified in opposition to this bill in the House Judiciary Subcommittee about 2 or 3 weeks ago. And I want to clear up some myths about legal settlements. Like I said, I've been an attorney for 20 years on 3 sides of the table representing industry, the federal government, and now an environmental nonprofit. And there's just some basic falsehoods and myths that are perpetrated about by opponents of settlements and really opponents of the laws that are being enforced as a result of settlements. The first is that settlements dictate regulatory outcomes. They basically dictate the results or conclusions of a rulemaking. That is absolutely false, demonstrably false. Every rulemaking that follows a settlement agreement has to go through notice and comment rulemaking, and it has to go down that chart. Okay? The outcome is produced by that chart. The outcome is not produced by a settlement. So the next point I've already stated, which is these settlements, the rulemakings that result from these settlements do not avoid notice and comment rulemaking. They do not avoid public participation. They do not avoid public hearings and all the other kind of trappings of the regulatory system that are designed to ensure that the input of people and the ability to sue afterwards if they don't like a result is fully preserved. Let me tell you one of the dirty little secrets why these bills are being pushed so strongly right now. There was a court decision last month or maybe 2 months ago by the United States Court of Appeals for the D.C. Circuit here in Washington. 3 Republican-appointed judges issued a unanimous decision that said that industry parties trying to intervene in a legal settlement between a federal agency and a third party, in this case I think it was an environmental nonprofit, Defenders of Wildlife, I believe, that if the industry parties are trying to obstruct that settlement and oppose that settlement merely because they oppose the schedule that the agency is agreeing to conduct rulemaking, again, that follows all of these requirements, those industry parties lack constitutional standing. They do not suffer harm within the meaning of the Constitution, okay? So they can't even have their case heard. And these 3 Republican judges bounced them, bounced the industry interveners, because they said, listen, if an agency is enforcing a statute and merely agreeing to a schedule to carry that out, you have all the opportunity to participate in the rulemaking that flows from that schedule, and you aren't even harmed within the meaning of the Constitution because you oppose merely a schedule. So what are they doing? They're running to Congress. Now, the irony is that Congress cannot cure a constitutional defect. Congress cannot confer constitutional standing upon a party that doesn't have it. But what they're trying to do is allow themselves to be inserted into the process as a matter of congressional right in order to obstruct those settlement discussions and therefore prevent the rule from being entered into. Well, if you don't believe me, just go read the bills, because what the bills basically say is if an industry party intervenes, it gets thrown into this black box of mediation involving courts. It forces plaintiffs to go into mediation and doesn't pay for any of their time that's spent, and it basically is just an open-ended process to prevent the settlement from coming to fruition. So, I hope that you will take away these stories, Regulatory Accountability Act asbestos, RAA asbestos, and I will stop there so that we could entertain any questions from the audience. Thank you again for coming.
Great, thank you, John. Appreciate that. And I'd like to underscore too John's point about just they can't get the votes in front of you, so they're sort of surreptitiously and quite overtly in some ways too. It's a death by 1,000 cuts, right? It's a very powerful mechanism. All right, are there any questions? I guess I could lead with just one from the moderator's standpoint. These folks must feel a bit under siege every single day. Can the panelists say something about the importance of, I guess Sid referred to it as resisting dysfunction, sort of the day in, day out defensive work that needs to be done?
I can mention a couple things. Let me mention this. It's worth doing on the merits. And it's not unpopular. There's a funny thing about polling on regulation. So the Pew folks have been doing public polling to ask the public about how they feel about regulation. And as you know, it all depends how you ask the question. So if you ask the question in general, does government regulation do more harm than good? There's a majority that says yes, it does. That majority varies. It's about 55 to 64%. So there's a slight majority that says on balance government does more harm than good. But then what Pew does is, they've been doing this for years, They asked the public about 5 regulatory areas: environmental protection, food protection, worker protection. And the question they asked the public is, do you support more regulatory protection, about the same amount, or less? And less polls, at best, about 25%. So 75% of the public, 7% of the public says, we're either happy with the amount or would like more. And of those two choices, more wins, almost always. So of the people who actually say, yes, we support government regulation, there's a plurality that says, and we should have more of it. Now, those numbers go up and down depending on the news and what's happening in a given year, but those go back about 20 years. So the public gets it. And again, this supports John's point that a frontal assault on the Clean Air Act or on the OSHA Act isn't going to work because people say, oh, yeah, that protects me. But what the other side has been able to take advantage of, go back to these myths, right, is this kind of general, mild public concern about government. We've always had that. I mean, going back to our Constitution, Americans are reasonably suspicious of government. Okay. But they also recognize the benefits of positive government. You can explain why you're opposing these things. And then you can explain it in terms of the kinds of stories that John just said, and it works. People get it.
I think one of the most important things to keep in mind, and I tried to make the point, and John did as well, is that these protections matter. They're important. They have an impact. And what has happened with this regulatory debate and attack is it's an attempt to basically have this be talked about in terms of process and burdens. And one of the most important ways that those of us who fight these terrible proposals but also advocate is trying to bring forward and involve in the process the people who are impacted. So when we went through a huge regulatory attack back in the Gingrich years, as John mentioned, and had a lot of Democrats supporting these bills, it was really quite difficult. The way it was stopped was bringing mothers whose children had been food poisoned and died from E. coli and Jack in the Box exposures, and they were the ones who came forward and said no. And so I think one thing that is discouraging, however, is that the process, the whole legislative process, the regulatory process, really has been captured in so many ways by the folks that have got the money, who have got the influence. And so people, just regular people, workers who need a silica standard, they don't feel that they've got a shot. Right? They think that the government has essentially been taken over, and that if you can't even move forward on things like crane safety when people are getting killed and everybody agrees on it, the government isn't working. And so I think that one of the situations that we face is probably the most discouraging, is that people have every reason to believe that the government is not working in their interest. And so how we change that and how we move forward with that being currently a reality, I think is quite difficult.
Yeah, I just want to kind of emphasize two things that we've been discussing. The first is that as a staff person, I would think that the crucial first step is to understand where these bills are Trojan horses, because all of these kind of industry coalitions and some of our political leaders aren't taking the time to draft these bills to preserve the status quo. I mean, there's something very clear that they are trying to undermine or obstruct or weaken. And there are some excellent organizations in this town with experts across the various substantive safeguards that have, sometimes banded together out of common interest. The Coalition for Sensible Safeguards, the Center for Progressive Reform, Many of us are part of these entities because we recognize the value of safeguards for the public. And so, don't hesitate to call upon these experts to help you identify those Trojan horses. And the second point I can't emphasize enough, which is that these safeguards matter to help real people. And so finding the stories of those real people, I have felt, has always been the most effective political strategy, dating to the days of the dirty meat bill that Peg alerted to. That's what turned the tide, is these stories of real Americans that were harmed by these efforts that were able to come forward. So it requires a little bit more work maybe to track down the people who are adversely impacted. But again, there are folks out there that are happy to help and happy to help find them, to have their stories told, because we know who succeeds more frequently in having their stories told in Washington, and it's often the corporate groups that have a lot more money than everyday people that don't have their stories heard as much. So again, I've just found that storytelling to be the most effective way of shining light on what these bills are really trying to do.
I might just follow up on John's point that there's lots of help available, and pick up on one of Peg's points. Peg pointed out that when we fail to protect the public, let alone the environment, it's not as if those costs just simply disappear. I mean, they're paid for. And they're paid for by people who are harmed in one way or another. So, for example, CPR has an actual study where we tried to calculate some of these opportunity costs and who pays for them. And it turns out, and this is very hard work to do, there just aren't hard numbers. So I think the study is about as good as you're going to get. But what taxpayers don't realize is the taxpayers are paying. And an enormous amount of this burden floats back onto Medicare, floats into food stamps, floats into, so essentially all of us are subsidizing these spillover costs that are imposed on us by all of these industries. So, right, they try to have it both ways. Regulatory costs, right, don't do any good. And the costs that are unprevented don't exist. I mean, that's not a real world position. And somehow we just have to do a little better job of making that understood.
I'm Nia Dell with United Food and Commercial Workers, and I went to the confirmation hearing on the Senate side, the new director of OIRA, and I was dismayed by the lack of attendance by Democrats on the committee, and even by the level of engagement by the chair of the committee. They just didn't seem to be taking that seriously. They kept talking about common sense, which is bizarre. So what I'm wondering is there an opportunity with the Shalansky confirmation to do something more proactive? Letters to the president, something in the media, a way to draw attention to the impact that this review process has on our regulations?
Well, for one thing, let's hold his feet to the fire. Because he did promise to move these regulations that have been stalled forever out. And so that's a promise on the record. And if he does it, great, because the public will benefit. If he doesn't do it, then I think both the public interest community and your congressmen or senators have to let him know that he's not keeping his promise.
I think it really is important, to call these folks out and to call out the Obama administration where it's failing. It's done a very good job in safety and health on the enforcement side. It really has improved enforcement with, limited resources. They've looked to add money. They've enhanced worker rights and all that. They're doing a decent, good job given the circumstances. In the regulatory arena, it's terrible. It's absolutely terrible. And so I do think it's important to be very clear about the record and what is going on and to hold them accountable. And so that is really, I think, very important. And with the new head of OIRA. We'll see, but it's not the head of OIRA. It's, the White House, it's the administration, it's the president. And I think we have to be clear about this, that the administration's record when it comes to workplace safety, maybe getting better on environmental protections, we'll see. A lot of those protections in the environment have come as a result of court actions because there are deadlines in the Clean Air Act, which in the occupational area there aren't. There aren't any mandates for standards, and so we suffer here in terms of trying to push the government to do its job because these are not mandatory standards, they're discretionary. But I think we really do need to be more public about this and call them out, and hopefully look to some of the new senators who are coming in, do education with new members. I think that's really, really important because many of the people who were around when these laws were passed and were the champions back then, they're no longer here, they're no longer with us, and so we've got a big job to do in terms of education. And there are some new members of the Senate, some members of the House, I think, that we have to look to become our new champions in these areas.
Just one point, there was a very helpful letter by about half a dozen Democratic senators urging responsible steps and action by this White House office to stop blocking safeguards, including the silica rule. It's a wonderful model or precedent for Democratic members on the House side if they're so inclined to get engaged. And it's perfectly responsible to urge a Democratic president and administration to move on enforcing the law. These laws were passed by Congress, and Congress has an interest in seeing them upheld. So if others would like to see that letter, I'm sure that one of us could provide it. It's in our inbox somewhere, and we'd be happy to provide it.
Okay, I think we have time for maybe one more question. Anyone? Okay, great. Well, thanks again to Representative Conyers and Representative Cohen, but thanks especially to the panelists, and thanks to all of you. We hope to make this a series of briefings, and so look for progress going forward. So thank you.